And where's Tan Kiat?
Mr. Speaker, sir, I thank the members for their comments and support of the bill. They have raised a number of issues and let me address them. Mr. Louis Ng asked about the impacts of the reliefs and our considerations for extension. Firstly, we have laid out some of the considerations in my second reading speech earlier. I want to assure the member that we recognize that relief measures are interventions into private contracts. The sanctity of contracts is fundamental for Singapore and a key aspect of the rule of law. Hence, this is not a decision that we have taken lightly. In this exceptional circumstance, we need to intervene to safeguard and preserve the capacity of our built environment sector by supporting the entire value chain. The industry has also consistently provided feedback to us that the ongoing moratorium on legal proceedings during the COVID-19 pandemic has proven very useful in helping the sector focus on staying on its feet. Mr. Ng also asked about the percentage of parties that have been able to resolve their differences amicably and in a beneficial manner. For construction and supply contracts, there have been about 1,100 notifications for relief filed as of 19th of March 2021. Of those, only about 118, or about 10% thereabouts, eventually applied for assessor's determination. This suggests to us that the majority were able to come to some satisfactory compromise on their own about contractual obligations affected by COVID-19. The relief provided under this Act provides a framework for conversations to happen so that firms can amicably settle their differences and move projects forward if they can do so. Ms. Sylvia Lim asked about Part 3 of the Act. To clarify to the member, while the sunset period for Part 3 ends on 19th of April 2021, nonetheless, the measures relating to insolvency in Part 3 had already lapsed into October 2020, as the prescribed period was from 20th April 2020 to 19th October 2020. These are exceptional measures that temporarily suspended creditors' rights to provide breathing room for financially distressed debtors to negotiate with creditors and pursue next steps, including for personal bankruptcy, the individual voluntary arrangement and debt repayment scheme, for corporate insolvency, out-of-court walkabouts, schemes of arrangements, judicial management, and simplified insolvency program. For sole proprietorships and partnerships, the sole proprietor and partnership scheme. Such exceptional measures should be carefully monitored because the measures also affect creditors and therefore flow of credit to other businesses. There has been no significant increase in number of personal bankruptcy and corporate insolvency applications comparing the figures for applications pre-COVID and the post-lapse of Part 3 measures in October 2020. We have been monitoring the situation and will continue to monitor it. Mr. Henry Quek and Mr. Louis Ng brought up the immediate challenge of the manpower shortage faced by the industry. And I agree with both Mr. Henry Quek and Mr. Louis Ng that beyond the temporary relief measures, it is important to address this situation. To elevate the current labour shortages in the construction industry, we are working closely with the Ministry of Manpower and Ministry of Health to progressively increase the number of incoming workers, but in a safe way, to minimize the risk of COVID-19 transmission in our dorms and to our wider community. I thank Mr. Quek for his suggestion to set up commercial processing facilities overseas to enable testing. Indeed, there are many operational challenges that we need to overcome to ensure reliable testing overseas, but we are actively in discussion with industry partners, including the Singapore Contractors Association Limited, or SCAL. And we are looking at how we can enable and establish better upstream processes to enhance pre-departure testing for workers in source countries. I also agree with Mr. Ng that there is value to retain experienced workers in Singapore as much as possible. However, as Mr. Quek has pointed out, there are also workers who want to go back to their families, and there are indeed workers who went home and could not return or would not like to return. But however, we are trying to keep as many of our Singapore workers in Singapore, here in Singapore. In this regard, SCAL, with the support of the Ministry of Manpower and BCA, has set up a manpower exchange, or SCMX for short, to facilitate a change of employer for construction workers, for workers whose contracts with the existing employers have either expired or terminated. This will help us retain the experienced workers who want to remain in Singapore. On Mr. Ng's suggestion to facilitate the rehiring of workers who return to their home countries and want to come back to Singapore to work, we are very pleased to have them back in Singapore, and employers know who they are and have applied for them to re-enter into Singapore. However, the constraint is not this. The constraint now and the challenge we are facing is how to allow these workers to come back, to re-enter Singapore in sufficient numbers to meet the industry's manpower needs, while minimizing COVID-19 importation risk, so as to safeguard public health. We are closely working with MOM and MOH on these aspects. Mr. Vikram Nair rightly pointed out that a cash flow is a lifeline of the construction industry. BCA monitors the progress payments in the industry closely and receives frequent feedback from key developers and contractors. This is also why we need to extend the relief under the Act so firms do not get engaged in long-drawn litigation at this point in time. During the circuit breaker period, most works were suspended and contractors received no progress payment. What we did to facilitate the cash flow was for government agencies, and some private developers have also followed suit, to provide advance payments to help contractors tide through this challenging period. For public sector projects, we have provided at least $665 million of advance payment in total. The government has also provided financial support, including waivers and rebates of the foreign worker levy and subsidies for rostered routine testing, or RRT for short. Mr. Vikram Nair also asked about co-sharing of additional costs for delays due to COVID-19 under Part AB, and how easy it is for such prolongation costs to be shared. To facilitate such claims, BCA and SCAL have jointly developed a claims template and detailed guidelines which are available on BCA's website. In addition, BCA has been working with SCAL and other trade associations and chambers to streamline the claims process. This includes introducing an accepted method to estimate the delays to projects due to COVID-19. We'll continue to work with the various stakeholders, including SCAL and other government agencies, to expedite the claims process. Lastly, under Part 8B, contractors can also seek recourse for cost-sharing amounts that are due but not paid through the existing education mechanism under the Security of Payment Act, or SOPA, which the industry is very familiar with. Mr. Donwy suggested that we inform the industry and banks on the extension of a period where developers are prevented from calling on the performance bonds or contractors. Mr. Wee may be pleased to know that a provision for deferment of call of performance bonds is already provided for in the Act. MND and BCA have been in close contact with the industry, and we have updated the industry on extension of the arrangement under the Act, including through a press release. Mr. Donwy also brought out the impact on the construction industry and how it has affected home buyers whose premises under construction have been delayed and who have to make alternative arrangements. And Mr. Vikram Nair has also asked about the extent to which these purchases have been affected. The number of purchasers seeking reimbursement under Part 8C, the number of purchasers seeking reimbursement after Part 8C comes into operation in a few months will depend on the number of projects delayed and whether developers need and choose to tap on this relief. It is in the interest of the developers for projects to be completed in a timely manner without having to tap on relief. Currently, based on updates from developers for projects expected to be completed in 2021, most are still on track to meet their respective dates of delivery of possession. We have also been encouraging developers who are unable to meet the date of delivery to first discuss with their purchasers and come to a workable and mutually agreeable arrangement. and this may result in a better outcome for both parties. Let me assure members that even as we provide relief to developers, we recognize that purchasers face challenges on their end as well, and we have structured Part 8C accordingly. Under Part 8C, developers who face construction delays due to COVID-19 and require relief may serve a notice for extension of the delivery date for up to 4 months or 122 days, which is aligned with the period in Part 8A. Mr. Don Wee asked why 4 months, why 122 days? This was also shared during the second reading of the COTMA bill. It's because construction work stopped for approximately 2 months due to the circuit breaker period, and works were further delayed by at least another 2 months as all the dormitories were cleared in early August 2020. Therefore, adding 2 months together, 2 plus 2, that's 4 months and 122 days. Should a developer need further relief for the delivery date to be extended by more than 122 days, they can apply for an assessor's determination of the length of construction delay, that is, to a material extent caused by COVID-19. Mr. Don Wee also asked about whether this relief will be applied to developer where HDB is the developer. I would like to share with Mr. Wee that for HDB flats, purchasers can similarly claim up to 70% of the prescribed LD formula, which will be aligned with that for the formula stated in the Housing Developers Rules for private residential properties. This allows for co-sharing of such costs between the developer and the purchaser. And if any disputes over reimbursement, both parties can seek an assessor's determination. To also reply to Mr. Don Wee's query regarding the assessors, similar to Part 2, the assessors making the determinations under Part 8C will be professionals with qualifications and working experience in the relevant fields, such as law, accountancy, finance, or building and construction. There will be mechanisms put in place to ensure the assessors declare any conflict of interest upfront. Ms. Yuva Lim asked why Part 8C is not in operation yet and why amendments to Part 8C are being made at this juncture. There are many urgent parts to the amendment that we moved in November last year, including Part 8, Part 8A, and Part 8B, and we have made sure that those parts are in operation as quickly as we can. For Part 8C, we have been in active discussion over the last few months with the industry and partners that will run and operationalize the relief framework, and we are making amendments now as we incorporate their feedback in preparation for the operationalization. We aim to streamline the process and help it be implemented more smoothly and more efficiently, given that it will be in fact for a longer period of time as compared to other acts, other reliefs under the Act. Ms. Lim will be pleased to know that the relief will apply to all affected agreements for the sale and purchase of housing, commercial, and industrial property that meet the criteria stated in the Act, regardless of when Part 8C comes into operation. Hence, developers will be able to tap on it after it comes into operation in a few months, and purchasers will be able to seek reimbursement then. Ms. Lim also asked how we will address the issue of fairness, given that legal representation will not be allowed as a default under the assessor framework, and she spoke in support of it. As with other parts of the Act, the assessor mechanism is designed to provide for a quick and effective practical solution to disputes. The overarching role of the assessor is to make a decision that's just and fair in the circumstances, and they have the power to ask for the appropriate information and documents from both parties, including information or documents not sought for by either party to achieve this. Ms. Lim raised the concern that a company may be represented by a legally trained employee. In the first instance, we hope to minimize the need for developers and purchasers to even require an assessor's determination, and we will lay out clearly the qualifying costs that purchasers will be able to seek reimbursement for to make the process more efficient and easy for everyone. The member will also know that in the ordinary case, if the matter were to go to court, the company would have a right to legal representation. Therefore, we have taken the position that for assessments, companies cannot be represented by lawyers. But there is a difference if we say that no one who is legally trained should come before an assessor. What if the individual purchaser himself is legally trained? The point is that the assessment framework seeks to give relief on very simple facts when there would otherwise be no relief. So simple process, simple facts. In the first instance, we hope to minimize the need for them to come before an assessor to seek determination. Mr. Speaker, in conclusion, the amendments before the House today seek to provide continued support to the built environment sector to ride out the lingering impact of the pandemic. I thank members and the industry stakeholders for the strong support for these measures and to continue to support the sector for staying on its feet.
Clarifications, if any? Thank you. The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The COVID-19 Temporary Measures Amendment Number 2 Bill.
Committee stage, what day?
Now, sir.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 9 stand part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for National Development.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendments.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The COVID-19 Temporary Measures Amendment Number 2 Bill.
Order. I propose to take a break now and suspend the sitting, and we'll take the chair at 4:20 p.m. Order. Order.